قانون اساسی جدید. یکم خودم شخصا موندم که انگلیسی با بگم یا فارسی حرف بزنم. شاید بزنم مثلا برم به زبون ابا اجدادیم گیلکی صحبت کنم، شاید بهتر باشه که دیگه کاملا بیان بشه. Allow me to introduce the panelists in English. I'll start with Dr. Roger Pilon, Vice President of Legal Affairs and Director of the Center for Constitutional Studies at Cato Institute in Washington, D.C. Dr. Pilon has served in Ronald Reagan's administration and State Department and Justice Department. We are very delighted to have such high caliber constitutionalists. I'd like to use that myself in particular with us. Next to Dr. Pilon, we have Ms. Saye Hassan. She is a lawyer, an activist, Iranian-Canadian lawyer, pro-democracy activist. She has her own blog called Shiro Khorshid Forever and is in very close touch with folks inside of Iran through her blog and other means. To my left is Mr. Fakhravar. I think you all know who he is. I'm not going to take the time any more than this. Last panelist, not the least, of course, Colonel Khairha is our beloved fighter pilot, who after Islamic Revolution was imprisoned in Iran and was handed an execution charge. He was to be executed. However, maybe there is a silver lining in the clouds, they say. The attack to Iran by Iraq, by the lunatic Saddam, made the regime in Iran to think twice to keep such treasures in jail. So they asked him to defend Iran, which they did. And in due time, Colonel took the time and left Iran so we would have the treasure with us, at least outside of Iran. So one day we will install these treasures back in Iran. We have lots of young people who would love to become pilots and they would love to be your student. Before any further ado, I'd like to ask Dr. Pilon to please take the podium and we'll be all ears here.
Very much, and I want to especially thank Amir for inviting me to appear before you today. Amir, I should say at the outset that I am not an expert on Iranian affairs, much less on Iranian legal and constitutional affairs. And in that connection, Amir has asked me simply to talk to you about the American Constitution and more precisely the principles that are behind that, insofar as they may be useful to those of you who are thinking about these things long and hard, and indeed one hopes will one day be in a position to yourselves apply principles like this as you sit down to think about how to either to revise the Iranian Constitution or even to replace it. And so that's what I will do. Before I do that, however, I want to just make a couple of preliminary points, namely that only the Iranian people can, of course, draft a constitution. At most, outsiders can give you advice, can give you counsel of various kinds, but it will fall to the Iranian people themselves to do so. And closely related to that, there is no such thing as a one-size-fits-all constitution. A constitution must spring from the soil of the country. It must reflect the culture, the heritage, the history of the country. And so what I am going to do today is try to focus upon some large principles insofar as they may be in time useful to all of you. To say that we in America have not solved all of these problems yet, and I will give you just the clearest example of that. James Madison, who was the principal author of the American Constitution, wrote in the Federalist Paper, number 45, that the powers of the new government here in Washington, eventually, would be few and defined. Now, those of you who are familiar with American government know that Washington and the federal government today exercises powers that are anything but few and defined. And so one of the great questions is, how did we get from an original design for a government of limited powers instituted to secure individual liberty to the kind of Leviathan that we have today? Hold that question. I'm going to get to it in just a few minutes. But I want to just leave you immediately with this notion that we have not solved all the problems either. But we've done a pretty good job of it. We have the oldest constitution in the world that is still in existence, and it has served us pretty well when you look at the rest of the world over the past 200 and more years. And why is that? It's because the framers of the Constitution got it right for the most part. Not entirely, to be sure, but largely they got it right. And what do I mean by that? I mean they established a government that, for the most part, serves the functions that the Constitution set out for it, and does so leaving us largely free to plan and live our own lives. And when you look at the structure of the Constitution, it gives you an insight about how it was that they accomplished that. The place to begin, however, is not with the Constitution, but with the Declaration of Independence that was written 11 years earlier. And as its very title suggests, it was written to declare our independence from Great Britain. But in doing that, Thomas Jefferson, the principal author, and those who signed the Declaration were standing on the shoulders of giants stretching all the way back to antiquity. They placed us, as the very first paragraph says, in the natural law tradition, the tradition that holds that there's a higher law of right and wrong, the natural law, from which to derive the positive or actual law, and against which to criticize that law at any point in time. That notion of a higher law or natural law can be found, as I said, in antiquity, in the writings of Plato, in Aristotle, in the Stoics after the demise of the Greek city-states. You find it in Roman law, in the writings of Cicero, and even more in Seneca. You find notions of it in the Middle Ages on the continent, in the struggle between the Pope and the King over jurisdiction, and you have an inchoate notion of separation of powers there. But most of all, you find it in England with the evolution of the common law over some 500 years, with judges deciding cases or controversies that were brought before them between individuals and later between individuals and the king. And in the course of developing the common law, they developed the theory of rights that would evolve into the natural rights tradition of the Enlightenment. And all of this was drawn together by John Locke in his second treatise of civil government, in which he set forth the theory of rights, the theory of property, and the social contract theory. And the theory of rights was rooted in two fundamental rights, property and contract. By property, he meant lives, liberties, and estates. The wrong in killing a person is taking something that belongs to him, his life. When people commit murder, rape, when they, or that of the Declaration, stood in what is called the state of nature tradition. The idea was to get clear about what the moral order is first. And you see that in the Declaration. All of these principles I've spoken of so far are rooted in reason. The natural law tradition that I'm alluding to is not the tradition that is rooted in religion, and mark this point carefully. It's rooted in reason, going all the way back to the Stoics, who saw natural law as being universal, applicable to all mankind and every place, whether it be Japan or Syria or Iran or South Africa or Argentina or wherever, because man has reason. And that's the principal foundation for the theory of natural rights. Look at the Declaration, and it says, we hold these truths to be self-evident. What are self-evident truths? They're rooted in reason. And what are they? All men are created equal, and you define that equality by reference to our rights to life, liberty, and the pursuit of happiness. And in this notion of pursuit of happiness, you have an insight into the mind of the classical liberal. It is a mind that distinguishes rights and values. They're very different moral notions. We have laid that out in detail that I don't have time to go into here. And you see that the Declaration does that. It says that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the government. So notice, government is twice limited. It's limited first by its ends to secure our rights, and by the means that it must employ, which must be consented to by the governed. And so the picture that emerges from the Declaration of Independence is essentially a world of live and let live. It's a world in which each of us is free to plan his own life, to pursue happiness by his own values, provided he respects the rights of others in the process, to do the same with government there to secure our rights and to do the few other things that we may have authorized it to do. And that's the vision that the framers, 11 years later, took with them when they sat down to draft a constitution for a more perfect union. We lived for the first 11 years under the Articles of Confederation. I turn now to the Constitution, and what you see here is that the framers of the Constitution took that vision and institutionalized it. It starts right from the preamble, which is in the state of nature tradition. We the people, for the purposes listed, do ordain and establish this Constitution. Notice, all power starts with the people. They create the government. They give the government whatever powers it has. The rest they keep for themselves. That's the theory of legitimacy that underpins the American Constitution. We create it, we give it its powers, they don't give us our rights. We already have our rights. Indeed, it's through exercising our rights that we bring this government into being. And then you look at the plan that Madison laid out for checking government. The government is, in its sense, a kind of tension. We give it powers, but at the same time, we restrain those powers. We give it power so that it can do what we want it to do, but we realize that this power can get out of control, so we check it with all the kinds of checks and balances that those of you who have looked at the American system of government see right there in the Constitution. There's, first of all, the division of powers between the federal and state governments, with most power left with the states. There is the separation of powers at the federal level among the three branches, with each branch defined functionally. There's the bicameral legislature, with each house constituted differently. There is the unitary executive, with the power charged to enforce the law and to serve as the commander-in-chief. There is, here I stress very importantly, the independent judiciary, the non-political branch, with the power to oversee the political branches to make sure that they conform to the strictures that are set out in the document. And finally, there is the power of the people through the elections to change the officers and to fill the offices that are set forth in the document. These are the main restraints. There are several other checks and balances, but those are the main ones. However, underlying it all is the most fundamental restraint, and it takes the doctrine of the name of the doctrine of enumerated powers. You see it in the very first sentence of the Constitution. All legislative power herein granted, notice granted, shall be vested in a Congress. By implication, not all power was herein granted. You look at Article 1, Section 8, and you see the powers that were granted. There are only 18 powers in Article 1, Section 8. That's all the power that Congress has. And then you see that the 10th Amendment makes that explicit. But notice, I've said nothing about the Bill of Rights. Why? Because there was no Bill of Rights in the beginning. We lived for 2 years without a Bill of Rights. Does that mean we didn't have rights vis-a-vis the federal government? No. We had rights because where there is no power, by definition, there is a right. So what the framers did was focus on powers, not on rights, and they limited those powers so that if there's no power, they are by definition free. That's the strategy of the Constitution. During the ratification debates, it became clear, however, that the Constitution would not be ratified unless a Bill of Rights were added. So one was added 2 years later. And it sets forth the various rights that we think of: right to freedom of speech, of religion, right to due process, right to property, and so on and so forth. But the 9th and the 10th Amendments capture the essence of it. The 10th Amendment says that the federal government has only certain powers, and if you don't find it there, then that power belongs either to the states or to the people themselves, never having been given up to either the federal or the state government. And the 9th Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So that means that the government has only those powers we've given it. The people have rights, both enumerated and unenumerated. And we lived under that conception of limited government more or less for 150 years. It wasn't perfect, to be sure. There was the oblique recognition of slavery. The framers wrestled mightily with it. They knew it was inconsistent with their founding principles. They hoped it would wither away in time. It didn't. It took a civil war, finally, and the passage of the Civil War amendments in 1868, in particular, the 14th Amendment, which for the first time applied the Bill of Rights against the states. Now, where did the great change take place? During the Progressive Era. At the end of the 19th century and into the early decades of the 20th century, we had something called the Progressive Movement. These were elites coming out of the elite schools of the Northeast, Harvard, Yale, Princeton, Columbia, and so forth. And what they were doing was looking to Europe and the experiments that were going on over there. They had a fundamentally different conception of government than the founding and subsequent generations. They saw government not as a necessary evil, but rather as an engine of good, an instrument through which to provide all kinds of goods and services to the people. The courts, for the first few decades, stood athwart that effort for the most part. They said, no, you don't have the power to engage in this kind of social engineering. During the New Deal, however, when the focus of the progressives shifted from activism at the state level to activism at the federal level, and one program of Roosevelt after another was found to be unconstitutional, Roosevelt, after the 36 landslide election, threatened to pack the court with 6 new members. The court got the message. He did not succeed in that, but the court got the message. There was the famous switch in time that saved 9, and the court began rewriting the Constitution without benefit of constitutional amendment. And so what we had there was the turning of the Constitution on its head. They abandoned the doctrine of enumerated powers, the very centerpiece of the Constitution. They then bifurcated the Bill of Rights, distinguished fundamental rights from non-fundamental rights, gave us 2 levels of judicial review, all of which serve to allow for the modern welfare state, the modern redistributive and regulatory state that we know and love so well today, to pour through. Well, that is exactly what has happened, and today we have a huge government here in Washington, but there is now a reaction to that. Those of you who have been following American politics know, of course, of the Tea Party movement, which has fundamentally changed the House of Representatives here in Washington. And today the cry is, we want a return to limited constitutional government, and so that is the tension that is going on here in this country. And so what you want to do when you think about these things is this. Imagine 2 poles. Down at one end is anarchism, no government. Up at the other end is totalitarianism, total government that controls every aspect of life. Think of North Korea, think of Cuba, think indeed sometimes of Iran. All right, you look at this and you see that as you move up here, there are certain interesting points at which to stop. Obviously, you come out of anarchy and you create government to protect you from national security purposes, to provide for police, for courts, and to provide such things as are called public goods by economists, such as clean air and so on and so forth. But the further you get up the line here, the more you're going to get into difficulties. Why? Because we are individuals. We have different values, and you throw everybody into the common pot, and you have every choice made through the government, and you will find you have unhappy people and happy people. No surprise that that will be the case. What do you expect? This is what you get up here when they tell you what schools you can go to, where your housing is, and so on and so forth. So you want to be careful as you move up this continuum not to give government more power and more programs than it properly should have if you're going to respect individual liberty. And so let me conclude by saying that we don't have a democracy in the United States. We have a constitutional republic. We have not kept it all that well over the years, as I have just suggested. But at the end of the day, the Constitution is itself a parchment document. It cannot enforce itself. It depends at the end of the day upon individuals, upon culture, upon the people protecting the Constitution by keeping it in their minds and in their hearts. And that, at the end of the day, is what you must do. The people must understand that they are themselves responsible for keeping their Constitution. Thank you.